Have you ever violated the terms and conditions of your non-immigrant status? That's the question that I'm going to answer today. I'm Josh Goldstein. I'm an immigration lawyer, and I help people just like you get work visas, green cards, and citizenship. So this question is on Form I-485, Part 8, Question 17. And this one is a real bugaboo. It blows my clients' minds, and it trips people up. And they get all twisted into a pretzel over this. And I have conversations with everyone about this. So this question comes into play often for people who are getting green cards through marriage. So if you have a husband or a wife who is a U.S. citizen and you're going through the green card, marriage-based green card process in the United States and you're filling out Form I-485, you have to answer all the questions on that application. And one of the questions is whether you violated the terms of your non-immigrant status. And the answer is it doesn't matter. So it's a yes or no question, but my answer is it doesn't matter. And let me explain why. If your spouse is a U.S. citizen, whether you violated the terms of your non-immigrant status is irrelevant. It doesn't matter. It doesn't matter. So in other words, if you came in as a visitor and you worked without authorization and you stayed in the United States beyond the authorized time for you to be in the United States, you violated the terms of your non-immigrant visa status. But it doesn't matter at all. You can still get approved for a green card through marriage to a U.S. citizen because it's not going to be a derogatory factor at all. The problem is that my clients don't know that and they're not convinced of that. So if they've worked without authorization or they've been in the United States and they haven't maintained their non-immigrant visa status, they're very reluctant to answer yes to that question. But actually, the bigger threat to their immigration case is giving false information to USCIS. So if they've worked without proper permission to work and they say no to the question about violating the terms of their non-immigrant visa status, that answer is not accurate and they could get tagged for misrepresentation. So most of my clients have worked without authorization. Most of them have failed to maintain their non-immigrant visa status. Answering yes to that question is accurate. It's not going to be a problem for you. Don't fear it and just embrace it. Go with the yes. Say, look, you know, I worked before my work permit came in. You won't have any difficult questions about this at your green card interview. And the answer is usually true or accurate, at least for many of my clients. Now, one more thing I have to say about this. If you're applying for a green card based on some other basis other than marriage to a U.S. citizen, failing to maintain your non-immigrant visa status could be a huge deal. So if you have an employment-based case, well, then that's a big deal. That could affect your eligibility for a green card. But if you're married to a U.S. citizen, then my concern is making sure that you accurately answer that question. And I would encourage you to consult with your lawyer about whether the answer to that question really should be yes, because that might be the correct answer for you. I hope this is helpful. If you have questions about this aspect of the marriage green card process or any other questions, I want you to get in touch with me. You can put a comment in the questions below or email me and get in touch with me, and I'd be happy to help you out.